Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Law of Torts. This is an example for damnum sine injuria. Damnum sine injuria. You can pronounce it as you like. There is a damage, but the injury is not legal. Friends, I told you the definition of a tort. Tort is a civil wrong which is not exclusively breach of trust or breach of conduct, and if any legal injury is committed, you can get compensation in the shape of unliquidated damages. This is according to section 2M of the Limitation Act, or the definition given by Salman, and I did not tell you the Winfield definition because it is a broad perspective. To decide whether it is a tort or not, the judge will have to see these two legal maxims: injuria sine damnum and damnum sine injuria. Injuria sine damnum, when there is a legal injury, of course, no damage would have been done, but still it's a tort. Damage done, but no legal injury. Damage done, lot of loss was accrued, but there is no legal injury. We can't help. Likewise, a religious liability is also not a tort. This is what is stated in the very famous case of Dhadphale versus Gurav. Dhadphale, Dhadphale versus Gurav, Gurav, 1881. The heading will be right to get food served on the idol is not a tort. I told you in a jocular way. ఒక పూజారి ఉన్నాడు. ఆయన దేవుడి విగ్రహానికి ప్రతిరోజు మధ్యాహ్నం 12 గంటలకి ప్రసాదం లేక భోజనం పెడతారు. ఆ తర్వాత ఆ భోజనాన్ని ఏకిస్తారు. ఏబిసిడి అందరూ తింటారు. దీంట్లో స్టాఫ్ కూడా తింటారు. ఒక రోజున పూజారి గారి కోపం వచ్చి, ఉన్నావా అసలు ఉన్నావా అని కోపం వచ్చి ఆయనకి అన్నం పెట్టడు. రిజల్ట్ ఏంటి? నెక్స్ట్ వాళ్ళకి లేదు. దే ఫైల్డ్ a case of tort that this man is not feeding the idol with the prasadam, as a result of which they are not getting. So please ask him to feed the idol with prasadam. The court said it's a religious liability. You can't help. It's not a tort. అదే కేసు ఇక్కడ. Now I'll repeat the same. So Mr. Dhadphale was a servant in the temple. Dhadphale అనే అతను అక్కడ ఊడ్చడం క్లీన్ చేసేవాడు. And Gurav was priest. Gurav was under obligation to get the food served, offered to the idol. Served and offered to the idol. So the obligation, that's why I told you, law creates what? Law creates rights, duties and obligations. Here the moral obligation or religious obligation of the priest Gurav is to offer prasadam or food to the idol daily at 12 noon. And as a ritual, Mr. Dhadphale has got the authority. As a servant, he has got authority. He has got a right to get food. So that prasadam will be first given to Dhadphale, then it will be served to all the bhaktas or all the persons who come to the temple. But Gurav failed to offer food to the idol. As a result of which, the chain reaction, these fellows did not have food. Therefore, they filed a case before the court as a case of tort, that because he is not serving the idol with the food, we are being starved. Please ask him. So direct him to offer food to the idol. Then the court said, it's a religious obligation, a religious duty. Religious duty cannot be imposed by law. So please remember, action for tort cannot be maintained. We cannot file a case of tort. So this is a negative example for the so-called torts, breach of religious duty. breach of moral duty. So it cannot be a case. This is another problem. So here, damage is there. Sine injuria, without legal injury. Here, it's not a legal injury. This man has been starving, but we can't help. It's a religious duty, a religious obligation particularly. So please remember, whenever any religious things do come to your notice, number one, better go to Hindu Charitable Endowment or Endowments Tribunal, number one. Second, under Article 226, you can approach the High Court for the redressal of your grievance, but civil cases, normally they will not take up this case. So to emphasize on this, damnum sine injuria, I have made this video. Please read the other case laws which I told you. So very, very important. Damnum Ashby versus White, all these cases. Please read them and enrich your legal knowledge. With this, I am concluding. Thank you very much.